One aspect of judicial review, one grounds for succeeding in a judicial review of a decision, is that the decision maker engaged in the process of decision making in a way that was contrary to what are known as the principles of natural justice. The rules of natural justice are common law principles that have developed over a long time. They're not fixed guidelines and written down rules that need to be followed, but they're what the judicial system has come to arrive at as a judgment about what's a fair process, what is a fair way of proceeding. And there are two guiding principles that underlie those notions of natural justice. The first of these is, they've both got Latin terms, the audi alterum partem rule. Excuse my pronunciation if that's not right. But what this literally means is to hear the other side too. So this is the principle that says that you can't just make a judgment about something without hearing the whole picture and hearing from the perspective of particularly somebody who's had an accusation levelled against them. In practice, it means nobody should be condemned unheard. Everybody is entitled to a fair hearing. Everybody is entitled to know their accuser, to know what the evidence against them is, to know what the case is, to have an opportunity to present their perspective, to argue their case, and so on. So you're taught to be able to appeal it, and so on, to know the rules by which it's being operated by. So this is this hearing the other side too. It's one of the things that when it comes to like national security issues, and the government doesn't want people to hear that information, that they're going against this fundamental principle. You also come in instances where this doesn't happen in cases of domestic violence, for example. If the process of establishing an order against somebody might alert that person and provoke them to be violent, you have what are called ex parte hearings. The law around those things is very controversial and complex because they depart from this fundamental principle that except in extraordinary circumstances such as national security or somebody's imminently being attacked by somebody else, this fundamental principle is that you must hear the other side too, that both sides should have a hearing. So that's the first principle. The second principle of natural justice is what's called the nemo iuex in causa sua rule. Again, excuse the pronunciation. This literally means that nobody should be a judge in his or her own cause. So if there is something that's being decided, it should be decided by a dispassionate, neutral arbiter. This is sometimes referred to as the rule against bias. And this anti-bias rule is associated with the common notion that justice must not only be done, but be seen to be done, so that the person who is the decision maker should be behaving in a neutral, unbiased way, should not be sitting effectively in judgment over something that they could be seen to have an interest in. What might bias involve? Well, a number of categories that might be biased. It would be that judgments shouldn't be influenced by situations where a decision maker has a pecuniary or financial interest in the outcome of proceedings, where a decision maker has personal attitudes or relationships or beliefs that have a direct bearing that might influence their bias or lack of bias, where the decision maker has a loyalty to an institution or an organisation that's implicated or involved in some way, where a decision maker has a prior involvement in the case, or a prejudgment of the issues. These are some of the examples of what might constitute bias or perceptions of bias, and therefore run counter to this second major principle of the principles, laws of natural justice. Now, as I said before, these rules aren't sort of written down and codified, but they are referred to, even though their specific details are left to judges to determine. They are referred to in the Bill of Rights Act 1990 in section 27, which is called the right to justice. In this part of the Bill of Rights Act, it says every person has the right to the observance of the principles of natural justice by any tribunal or other public authority which has the power to make a determination in respect of that person's rights, obligations or interests protected or recognised by law. So wherever an individual is subject to decision making by a tribunal or public authority, they are entitled to expect that that body will observe the principles of natural justice in arriving at that determination. Every person whose rights, obligations or interests protected or recognised by law have been affected by a determination of any tribunal or other public authority has the right to apply in accordance with law for judicial review of that determination. So this is part of this right to justice, is that where a decision has been made, it is supposed to be made in accordance with the principles of natural justice, and where your interests are affected by it, you are entitled to apply for judicial review of that ruling. Third subsection, every person has a right to bring civil proceedings against and to defend civil proceedings brought by the Crown, and to have those proceedings heard according to law in the same way as civil proceedings between individuals. So this is part of making the Crown responsible, public authorities as responsible as individuals are to behaving properly, behaving in a lawful way, behaving in accordance with the principles of natural justice, and having their actions scrutinised in court through this mechanism of judicial review where appropriate. What these principles of natural justice mean is a real importance on issues of process in making judgments. And for decision makers in educational institutions, this means that decisions must be made in such a way that people who are impacted by those decisions can participate in the process fairly. That's broadly what is being talked about, a fair process. In matters of discipline, whether of staff, although that has employment law implications as well, but this is an integral part of employment law as well, principles of natural justice. Whether it's disciplinary matters for students or for staff, this applies, includes factors like giving people notice of what they're suspected of, giving them an opportunity to defend themselves, keeping the process open and transparent, keeping an open mind, not being predetermined or coming to a conclusion too quickly, making decisions about whether any sanctions applied and making those fair, making them consistent and so on, giving them avenues of appeal, all of these sorts of things. The focus really is on process in relation to this issue of natural justice. Process is absolutely central, and so consultation on process would also be an important part of this process. So this sort of raises the broader question of when are these natural justice rules applied in education? And the tension here is really between the requirements to manage an educational institution or to administer an education system, and the rights of the people who are attending that institution or relying on it in some way, whether the families or communities or whatever. And there is this kind of balancing thing that the institutions need to be managed. People are delegated authority to manage them. There are no these natural justice are not specific codified things. You must do this, you must do that. And there is a certain amount of delegated power, but that power is tempered by the rights and entitlements of those who are participating in that institution, whether as students or as parents of those students or families and communities, if we're talking about broader afield. And so the question really is, how are these tensions balanced? How can institutions have the autonomy to make those managerial decisions on their own without too much court interference, at the same time as the rights and entitlements of people who come to rely on those institutions are also met as well. And fundamentally, when we're looking at this sort of issue, what role should the courts take in intervening on these sorts of points? And here, in terms of the courts, the way you find out is you look at the judgments and you look at the decisions that the courts have made. And you see that there are instances where the courts will get involved and become engaged and take a position. There will be other instances where the courts will step back and say, no, this is not our domain. We're not going to interfere in this. This is part of the responsibilities of the education administrators and managers to maintain those positions. And so to find out where those particular points are, you really have, this is one of these things that develops in common law on a case-by-case basis, and you can make an assessment of any given case extrapolating from the sorts of principles that were established from previous cases and say, well, this is the way the courts are looking at it. But, you know, that's how you kind of take your lead on these things.